Good afternoon, everybody. Welcome. Thank you so much for coming. Second year in a row. For some of you, it's a great pleasure for us from OTC to come and see you again. We've got a great team of people here. I'm going to talk on a variety of topics, silks and juniors. The great thing about this group is that everybody works together regularly on cases in teams of 2, 3, and sometimes even more. So the junior people who are going to speak to you know their stuff and are getting lots of great experience working on cases both on their own and with the silks. Mostly that benefits the silks, but apparently there's some benefits for the juniors as well. And they will be making a big contribution this afternoon to the various things that we're going to hear. One other preview. There is, as of last year at 4:30, a so-called fireside chat, which I will sort of host with Nick and Keith. We've got 3 topics that provisionally we will chat about. One is construction techniques, textual versus purposive, stroke scheme archaeology. There's been some case law that throws some light on that. 2, what's the threshold for going to court for a trustee when you've got leading counsel's opinion, and how should you go to court? 3, what are the trends in pensions litigation? If any of you don't like those topics or want to suggest others, let us know during the course of the afternoon and we'll try and accommodate it. Or you can put your hand up at the end and ask us a question and we'll try and deal with it. But on the basis that it isn't really meant to be a free advice from 3 leading counsel who won't know the answer and don't want to be embarrassed. But I just thought I'd let you think about that during the afternoon. Subject to that, that's what we will cover in that period. So without further ado, I will introduce our first speakers, Keith Bryant, KC, and Naomi Ling, who are going to talk about a very, very interesting case. I'm going to let them tell you everything about it, including its name.
Thank you, Andrew. For those of you who are members of the APL and may have attended a talk last night, you may have a sense of deja vu. That's because it's basically the same talk. So if you want to nod off, feel free. I should also tell you that we are now trying to cram it into 15 minutes, and it took an hour last night. So we may be going a little bit quicker than yesterday. But the upside, perhaps, is that you don't have counsel who represented the successful company. So we can put whatever spin on it we like. So courage, fetters, construction, severance, and compromise. Where are we now? The case we're talking about, next slide, please, is Avon Cosmetics and Dalriada Trustees and Others. And I am going to take this at a bit of a canter. If anyone wants to talk about it further, do grab me at tea time. There were 2 hearings recently in this case, and there are 2 judgments, both from the same judge. Hearing in December, a judgment in the middle of January, what we're calling the revaluation winners judgment, for reasons I'll come to in a moment. Another hearing in the middle of February, which was a compromise hearing. The first hearing being fully contested. This led to a judgment a few days later called the final salary winners judgment. I'm going to introduce this, as I'm doing at the moment, summarise the facts and tell you a little bit about the revaluation winners judgment. I should tell you the slides were written by the company counsel who gave that bit of the talk last night. I haven't altered them at all, but I may take that bit fairly quickly and then leave Naomi to tell you what the case was really about. In due course, she is then going to give you comment on the revaluation winners judgment, and we're going to skip over the final salary winners judgment, the compromise bit of it, and then there are a couple of slides at the end about where that leaves us. Next, please. So very briefly, what this is about, there's a scheme, the Avon Cosmetics pension plan. The company as the claimant, as typical in these sort of Part 8 proceedings, the trustees, current trustees, as the first 6 defendants, Dalriada leading the way, and then Mr. Pinnock, the chosen rep Ben as D7. Naomi and I acted for Mr. Pinnock, Richard Hitchcock, KC, and Lydia Seymour acted for the company, someone from another chambers acted for the trustees, but they were neutral, so they didn't really do very much. But I would say that, wouldn't I? Next, please. I'm going to skip over these really quickly because I assume you are all pension techies, so you know all this. If you want copies of the slides, I'm sure we can make those available later. This slide basically tells you what a final salary link is. It's even if you close your scheme to future accrual, you still get the benefit of any increases in final salary after the closure in relation to pre-closure benefits. That's what a final salary link is. Next slide, please. And then this is, in very brief terms, what a courage fetter is. And essentially, it's a fetter on your amendment power that, at least on the face of it, prevents you from breaking your final salary link. Next, please. So, some summary of the facts continued. Plan established in 1960, we were concerned with 1999 deed and rules, and you have set out here on the slide what the power of amendment said, or the relevant bits of it. The key bits for our purposes, and you'll note from the first sub-clause, it's a bilateral power, trustee with consent of the employer, amendments to be made by deed, executed by both. But then sub-clause 4, the relevant proviso for our purposes, the power of amendment may not be exercised in any way which affects prejudicially, and then little Roman 2, benefits accrued or secured up to the date on which the amendment takes effect. So that is your courage fetter, or your courage style fetter, however you want to put it. Next, please. So up to 2006, the plan had a final salary section, which was open to future accrual. It also had a care section. It also had a DC section. And what the company and the trustees did was introduce a deed of amendment in October 2006, did all sorts of things, but one of them was to close the final salary section to future accrual, and to provide that benefits accrued already in the final salary section would not be calculated on the basis of salary at time of retirement, but on the basis of pensionable salary at the date of closure, but then revalued up to retirement. Next, please. So you will all have worked out already, I'm sure, some members might be better off having their benefits calculated on that basis, i.e. salary at October 2006, revalued by the scheme revaluation provision. Others would be worse off, what we're calling revaluation winners and final salary winners. It all depends basically on whether your salary is going to go up by more than the relevant inflationary measure. So that left two key questions. Was the fetter engaged at all? Did the 2006 amendment engage the fetter? And therefore, was the amendment invalid or arguably invalid for FS winners, so the people who would be worse off as a result of the amendment? And if so, was it nevertheless valid in respect of revaluation winners? So even if it wasn't valid for some, could it be saved for others? Next, please. We now get into Lydia's slides, which I'm going to deal with very quickly. Really, this slide tells you what a revaluation winner and an FS winner is, and I've really done that. So next slide, please. Two short points here. Really, whether you are a revaluation winner or an FS winner is something that is fluid, because you don't know, certainly as at October 2006, what's going to happen with your pay rises, or indeed what's going to happen with inflation, as we have seen over the last few years. So ultimately, you're only going to be able to pin down who's in which category at date of retirement, or date they take their benefits, or go into voluntary deferment, or whatever it may be. Next, please. So questions arose about case management. Again, I'll take this at a canter, if not a gallop. What the company was planning to do originally, and indeed did do in terms of issuing the claim, was assume that revaluation winners would get what they had been promised all along, is the more valuable benefits based on the terms of the amendment, and that the only issue was about the entitlements of the FS winners, engagement of the fetter and what effect it had. Essentially that left the company saying, well, if we're going to pay the FS winners on that basis, and we're going to pay the revaluation winners on the revaluation basis, that's the most expensive of both worlds, as it were. And perhaps unsurprisingly, the Part 7 defendants in the prof neg claim behind this weren't entirely happy about that. So they raised the question of whether, if the fetter was engaged, that meant the amendment was invalid for everybody, basically trying to save some money in relation to revaluation winners. So one ended up with these two key questions, as I've already set out. And what was devised in the end was having two hearings. Ordinarily, you might think you would have what turned into a compromise hearing, because we negotiated a settlement of the FS winners position. You'd think you'd do that first, and then you'd have the contested hearing about the revaluation winners. The difficulty with that, or one of the difficulties with that, is either you have to have two judges doing it, and you've then got double expense of reading in and so on, or you would have the same judge reading confidential opinions in relation to the compromise hearing, and then trying to forget everything that was in them for the purposes of the contested hearing. So there was a real question, and it was batted about for quite a long time, as to which order do we deal with these things. We ended up dealing with the contested hearing first, and then having the compromise later, hence two hearings, two judgments. Next, please. So essentially, two broad arguments. One of construction: can you construe the amendment power so that it is valid for some, not valid for others in its exercise? And there is I might say, a relatively short line of authority of dubious provenance, which espouses that point. Doyle and relatively old case, and then more recently IMG. Or can you sever the exercise in some way? And relevant cases there, Best Trustees, Mr. Justice Neuberger, as he then was, and various other cases since. So two ways in which the case was broadly put by the company. Next, please. And the next few slides sort of set out in a little bit more detail the basis for the arguments. Best Trustees, and then picked up again in Wedgwood, a case close to Andrew's heart, I know, seems to set out a test for severance with two elements. One is, conceptually, can you separate the valid part of the exercise of the power from the invalid? Perhaps a typical example, as was in those cases, where you're trying to equalise normal retirement ages retrospectively. That doesn't work, but you can sever the retrospective effect from the equalising going forwards effect. So that was the first part of the test under Best Trustees. And the second part, which was the area where there was much more argument in Avon, was, well, would the power have been exercised differently, including not at all, if the trustee had known the true situation, that they couldn't do what they were purporting to do in its entirety? And the second main bullet point here says one of the key questions in Avon was to do with the second limb, and question of what if anything did the company have to show, and what was the test? Was it a subjective or an objective test? Next slide, please. This tells you a bit more about the structure of the arguments, which you may or may not be able to discern if you actually read the judgment. There is support for the Best Trustees in Wedgwood. For the Best Trustees, as I said, it was picked up in Wedgwood. and also IBM and the Court of Appeal, we say, rather endorsed that approach. But it has been suggested by company representatives that it adds complication to what they said was a simple construction exercise. And perhaps a more of a jury point, but perhaps with a little bit more force. A fetter designed to protect benefits would in fact have the effect of depriving one group of the benefits that they've been promised. Next, please. Pitt and Holt, I'm sure you can all quote the judgments in your sleep. This was heavily relied on by the company. And they said, in short, that best trustees, even if it says what we were saying it said, needs to be reconsidered in the light of Pitt and Holt and the Court of Appeal and the Supreme Court. So capable of overruling best trustees, which is the first instance authority. And you can see that the quote that is set out here from the Court of Appeal judgment, then endorsed in the Supreme Court, Lord Justice Lloyd. If the provisions that can and would take effect cannot reasonably be regarded as being for the benefit of the person to be advanced, this was an advancement case, not a pensions case, then the exercise fails as not being within the scope of the power of advancement. This, I suppose, is the key bit. Otherwise, it takes effect to the extent that it can. That was what was relied upon. Next, please. And the judgment, this is the first judgment from the December hearing, which is by far the longest judgment. It draws significantly from, as is set out here, contract law and public law. Interestingly, is one way of putting it, none of the stuff that's in the judgments about these was actually raised during the course of the hearing by the parties or by the judge. He obviously say something rather rude, so I should stop myself. But where he ended up, and if you are so inclined, do have a look at the judgment, because there are many, many, many pages talking about contract law and public law. When you actually get to the, and here's the reasoning to my conclusion, it's about a paragraph. Make of that what you will. But basically his conclusion was, well, the construction argument works. You can construe to rescue the amendment insofar as it would have been valid for some members, in this case revaluation winners. But even if not, and the reasoning's even shorter here, severance still works. And certainly as the company saw it, the key point was that the question is an objective one. So insofar as best trustees suggests that it's a question of what the trustees' intention would have been subjectively, that on their interpretation of this judgment is not right. That, I think, takes us next slide to where I hand the baton to Naomi.
So I think when we think about the way in which the judge was comparing and contrasting a subjective approach with an objective approach, he was saying that the subjective approach is one that required us to look into the minds of the trustees. What were they actually thinking at the time? What would in fact have happened if the trustees had understood that what they were trying to do wasn't possible? And he compared this with what he characterized as the objective approach, which is where you look at whether the valid part of the amendment was attempting to achieve the same purpose as what the trustees were in fact trying to do. So those were the two sort of different approaches the judge was comparing, and rejected the subjective approach in favor of the objective approach. And you can see that there are significant problems with taking that kind of subjective approach. And in rejecting it, there were plainly benefits insofar as legal advisors, trustees, companies are concerned, because in these sorts of problems, when they arise, inevitably they arise many, many years down the line. It's difficult sometimes to get hold of trustees. It's certainly difficult to get a trustee to be able to give that kind of evidence. They may not have been that strongly engaged at the time anyway. And I think it's fair to say, and I think this was something that was stated in both the Court of Appeal and the Supreme Court in Pitt and Holt, that question is not a straightforward one to answer. Because if you're saying to a trustee, would you have gone ahead with this change if you'd known that you couldn't make the whole of it? You know, almost inevitably, what the trustee would have done would have been taken different advice, got different advice, maybe even decided to make a completely different set of changes from the ones that they purported to make. The honest answer would be to the question, would you have gone ahead with this partial amendment had you known that the whole amendment wouldn't work, is probably, I'm not sure, I'd have probably had another think or taken some different advice. Could we have the next slide, please? There's also an extent to which, if you're taking a more objective approach where you're simply looking at what was trying to be achieved by the instrument that was in fact executed, it's potentially a more certain approach. And it has the potential benefit of being an approach that is consistent with the approach that has been taken in public law and contract law authorities. What I think is the real benefit, and I you know, even as someone who represented the Rep Ben and was sort of thoroughly immersed in all the arguments for the other side, I have to admit that the conclusion that the judge reached was by far the most sensible one in terms of managing employee relations and in terms of, you know, upholding respect for the law and pension schemes amongst members generally. It would certainly have created very significant employee relations headaches if the company had had to say to all of those people who were better off as a result of revaluation link, oh, you know, this amazing inflation you've been enjoying to your pension in the last couple of years, you don't have that, I'm afraid. That would have been tricky and somewhat unattractive. And another really quite unattractive outcome is, you know, what if you have one person in respect of whom the fetter is engaged? Does that invalidate the whole amendment for everyone else in respect of whom the fetter doesn't operate to their advantage, with the potential risk of sort of perverse outcomes and potentially even people using these arguments contrary to the purpose of the trust? Let's go on. But I do think, and I don't think this is just me, I think there are others who share this view, that there are significant difficulties with the judgment, not least, or perhaps because much of the judge's reasoning, and indeed most of the case law he cited, was not ventilated in argument. But was, I think, possibly the result of a lot of kind of late nights and kind of, you know, febrile thoughts on the judge's part. And just to kind of draw out a few of the sort of potentially problematic lines of reasoning employed by the judge. First of all, in Pitt and Holt, Lord Justice Mummery said in the Court of Appeal, and this was specifically endorsed by Lord Walker in the Supreme Court, it's not helpful or necessary to import concepts from public law or indeed contract law into trust law. And, you know, how often do we see this ever happening in trust cases? Vanishingly rarely, despite the fact that, you know, many of the concepts are at first blush really quite similar to each other. You know, the Edge and Pensions Ombudsman test for, you know, when you're allowed to interfere with the decision of a trustee is at first glance almost identical to the circumstances in which you are permitted, or the courts will interfere with the decisions of a public authority. But as Lord Justice Mummery said in Pitt and Holt, the reality is that in public law, the court's control is directed at whether a public authority is exceeding its powers under statute. In a trust context, the Chancery Division is controlling or has oversight over the way in which a fiduciary is exercising the powers that have been privately entrusted to it by a settlor with a closed class of beneficiaries, and certainly, in the context of trust law historically, with a finite pot of assets to be distributed. And so the role of the fiduciary in a trust context is almost always going to be to decide who is going to get what, or whose interests are going to be prioritized over whose, not something that a public authority is usually asked to do. Similarly, in contract law, there's no such exercise of determining whether a discretion has been properly exercised to prioritise different interests over another. In that case, the court is entirely uninterested in who benefits from the bargain, what was the nature of the bargain in the first place. The sole question is whether the contract can be allowed to stand or whether it offends against certain common law principles. Next slide, please. So that's that aspect of the judgment. I think the second aspect of the judgment that I'd like to sort of touch upon and discuss is this idea of what is the correct objective question. Because although in Pitt and Holt, the Court of Appeal and the Supreme Court was very critical of the idea that you should actually ask as a matter of fact, what would these trustees in fact have done? Nevertheless, at the very end of Pitt and Holt, we discover that where the trustees, there has been a flaw in the trustees' decision-making process sufficient to amount to a breach of fiduciary duty, we do ask ourselves the question, what would a reasonable trustee faced with this decision have done? So although it's an objective question, because you're asking yourself, what would a reasonable trustee have done, you're still allowed to look at extrinsic evidence. You're still allowed to consider the question in its factual context that the trustees were facing and the different interests that they are weighing up against each other, which goes back to the question of, whose interests were the trustees trying to advance, which was the Hastings-Bass question. That appears to have been a potential objective question that the judge simply didn't even ask himself, is this the correct approach? Because he went straight on to consider whether the public law approach was the correct approach. Let's have the next slide, please. So in the current context, when we look at 2006, what were the trustees trying to do? The reality was they were closing the scheme to future accrual, closing the scheme to further final salary accrual, and they were seeking to break the final salary link. Now, why were they trying to do that? No prizes. They were trying to cut the costs of the scheme. But the impact of this judgment is that not only does the company have to fund more expensive benefit for FS winners, but it also needs to provide those now considerably more valuable benefits for the revaluation winners. It's the most expensive option and it's the worst of both worlds. The judge concluded that the substantial purpose of the original amendment was to remove the final salary link and to link pensions to revaluation. That is certainly what was done. And there are cases where, you look at what was done to divine the purpose. That's very often, isn't it, the approach that the courts take to the question of statutory interpretation. But of course, there's a different idea of purpose that might well come into play if you were adopting that Pitt and Holt objective approach. Why were they doing what they did? And I would suggest that where the court ended up was to endorse the reversal of what the trustees had been trying to achieve. Let's have the next slide, please. And this is really sort of coming down to the question, opening up a huge and very interesting question of, well, what is purpose, which was not something, obviously, that was discussed and not something that I'm going to discuss now. But I do think that this judgment may perhaps not result in a valuable clarification of the law, in the sense that it's going to be a judgment for the ages that we come back to again and again to identify sort of fundamental principles of trusts law. I think that possibly what it does do is arrive at a pragmatic and sort of workable approach that is not going to create huge difficulties for employers and trustees going forward. But if you were to say, you know, does the Court of Appeal decision in Pitt and Holt best sum up the current position? Do the provisions that can and would take effect, can they reasonably be regarded as being for the benefit of the person to be advanced? I would say that the decision in Avon marked a significant departure and misunderstanding of that statement by Lord Justice Lloyd. Because the benefit of the person to be advanced really was the company in very significantly reducing the cost of managing the scheme. And insofar as the interests of the revaluation winners turned out in 2022 and 2023 in areas of inflation that were unprecedented in recent times, that was certainly not the benefit of the person that was intended to be advanced in 2006, albeit that, as we currently see now, they were quite significantly the winners out of this process. And so that was really sort of my thoughts, I think our thoughts, in the absence of Richard and Lydia, our collective thoughts on the matter. But if anyone else would like to weigh in or say why the judgment was brilliant or exactly the right thing, or indeed to agree with us, please do. Let's have some
But I
questions.
think do it over tea, probably.
Yes, probably that is best.